Welcome to Taking Care of Lady Business, where we put the business back in lady business. Hosted by Jennifer Justice, founder and CEO of the Justice Department, a management strategy and law firm that works with female and woke male entrepreneurs, executives, talent, brands, and creatives to build and maximize their wealth, focusing in the areas of tech, consumer product, finance, media, entertainment, and fashion. Jennifer interviews entrepreneurial women who have done it all, who will be sharing their secrets on all things business, especially as a woman. These highly successful women will share strategies and insights, including what not to do and what it takes to win. And now, here's your host, Jennifer Justice.
Hello, everyone. Welcome to this episode of Taking Care of Lady Business. I am Jennifer Justice. Today, we are going to talk about something that's important to all of us, and that is getting paid, and executive compensation. So I brought on an amazing specialist in here, Regina Readling. She is a partner at Weil, Gotshal, and this is what she specializes in. So I'm excited because everyone knows, if you've listened, like, I'm very passionate about this, and I'm passionate about women hiring people to represent them, not negotiating for yourself. And we're going to talk about when you do it. Hi, how are you?
Hi, JJ. So happy to be here.
Yeah, I'm glad you're here. So tell us a little bit more about your background and what you do, and then we'll get into the specifics.
Great. Happy to. So my name is Regina. I'm a partner in the executive compensation group at Weil Gotshal. I'm recently new to this firm. I started my career about 14 years ago at another white shoe firm in the executive compensation practice. And a lot of my time is spent doing M&A transactions, but within that context, really touching anything that impacts people. So it's equity compensation, it's employee benefits, and a lot of what we're talking about today, it's employment agreements and how you think about going into an employment agreement on the front end. And frankly, looking forward to what might happen on the back end when you're negotiating a separation or a severance agreement.
So let's unpack a little bit of that too, right? So people who are not going through this yet, but maybe will be going through this in 5 years. What do you mean by M&A? And give us an example of like some, you can use fake companies, but like what that means.
Absolutely. So I do a lot of public company work. So companies that have, securities stock traded on the New York Stock Exchange, NASDAQ. And when one company is looking to acquire another company, there's a whole life cycle of work that goes into that. So, for instance, I just did a deal in the grocery industry where a big grocer has purchased another competitor, frankly, in the field. And, a big part of that work is first understanding, what the target of the acquisition or the other side of the deal, what employment arrangements do they have for their employees? What type of equity arrangements do they have for their employees? So it's what we call kind of due diligence, really information collecting and helping my client understand, the compensation and benefits landscape of, what the target that they're looking to acquire has. So it's really working with companies through the life cycle of exploring acquisitions, understanding what they need to do in terms of integrating compensation and benefits. And then on the back end, once they've integrated things, either rolling out new programs or, new benefits for folks.
Right. Okay. Got it. And then when you're doing that, when you're talking about the compensation, you're talking about only executives at the company, or are you talking about all the way down to, hourly workers?
Yeah, and that's a great question. It totally depends. For example, I worked on the Amazon Whole Foods acquisition, and at Whole Foods, they gave every single employee equity from the top all the way down to the bottom. So in that regard, it was a much broader population, and thinking about, how we treated those awards in the context of doing the deal. In other companies, it's much more, as you can imagine, concentrated at the top. So in that regard, we might be thinking about, well, the senior team has equity, but we really need to keep everyone engaged for purposes of doing this deal. What type of retention awards and other bonuses do we need to put in place to incentivize people to, act in a way we need them to act to get the deal done?
Right. Okay. So then let's go like deeper into executive compensation and these agreements, right? And the components of it. Which I'm always like saying, as I said in the beginning, like you should have people negotiate for you. You should have, especially if you're an executive, there's no reason you should be getting paid enough to be able to have this, work. And then, in addition to salaries, obviously there's other components,
Totally.
right? That you have to
Totally.
look, at. So can you just start talking about the different components of an executive compensation like package or
Sure.
agreement?
Sure. So when I think about an executive compensation package, obviously the first part is the comp. So what is the person getting paid? And in my mind, I usually break that down into three components. It's salary. So what are you getting as your base salary? There's typically an annual bonus component or a quarterly bonus component, depending on the industry. And then the third piece of that is equity. And a lot of times that could be options, it could be restricted stock units, or it could be, a type of equity award that has a performance overlay to it. And again, that last piece really depends on, the company, the industry, and what the employer has in place already.
Right. So a lot of tech companies have lower salaries and then they give you equity.
Exactly
But
right.
equity is no compensation until it is compensation.
Right.
And even then, it
Right.
could be nothing, right?
Right. And that's a huge, look, that's a huge part of, bringing in someone to represent you to understand, I think, one, just from a practical perspective, what are the tax implications of the awards I'm getting? What is the likelihood of, that me realizing value? What is the time horizon? What are the triggers? And also, if things go poorly and I leave or I don't make it to the, ultimate liquidity event, what does that mean for purposes of my awards? And those are things, look, on the way in, if you have some leverage, I think that's when you should be having those discussions, not on the way out when the relationship has soured and, the facts are different.
All right. So when do you typically see someone hiring an attorney, or when, by the way, when, in your opinion, should they be?
Yeah, that's a great question. So, look, I think a lot of times people, in my experience, engage an attorney at a point where it's a little too late. And I can talk a little bit more about that, what that means. So I think in the life cycle of doing an employment agreement, typically what happens is you have some type of, meeting of the business minds. So from a business deal, we know what the dollars look like. We kind of know what the broad sketches of the offer look like. And a lot of times those conversations are going on somewhat informally between the company and the executive. In my experience, usually before an attorney has been engaged. I think it's too late to engage someone after that stage because there are so many important terms, you know, on equity, on maybe certain protections around severance that are usually on that sheet of paper. And, look, I think there's always room for negotiation, but you're coming from a very different negotiating point if you can be having those discussions. And frankly, if you as an executive can have your attorney be having those discussions on your
Exactly.
behalf.
Right. So, I mean, but to clarify, you should still hire an attorney because all of that other language, there's non-competes that aren't and non-solicitations that aren't even legal in some states
Right.
anymore. But like you should hire one. But the whole point here is before you even have a conversation, when they put something in front of you, or which they should never do, what do you want? Right.
Right.
Because in like now New York, they can't ask you what you made before.
Exactly.
They also have to put what the salary range is now,
Yep.
right? Which just passed very recently. But in general, you should have somebody negotiating every single thing. You should not be naming what your price is. You should not be like going back and forth. You should engage someone.
Right. And I
And
think that, and sorry to interrupt, but the benefit also is, at the outset, I think people are always on good terms, but there may be things that you want or that are important to you. You should be having those discussions with your attorney so that he or she can really go to play ball with the other side, because a lot of times I know kind of where some of the pressure points are. And I
Yeah.
think it's important to strategize about how you want the negotiation to play out. Again, on good terms, but you should have someone that's willing to kind of,
Push.
be the liaison and the go-between between what you want and the deal that you're negotiating for yourself.
Yeah, I find like when I have clients that are just fine with me just going for it, like I ask for everything, knowing I'm going to get half of it.
Right.
But if I only ask for half of it, then I'm only going to get a quarter of it,
Exactly.
right?
Right.
But
Exactly.
I do that, okay? You shouldn't do that as the executive. Let me
Right.
do that, and I push all the buttons. And then, they go like, look. And half the time, what happens behind the scenes, like a lot of clients, in particular women, like, oh, I want to be nice. I don't want to like push. They like the other side is not going, oh, they're going like, oh, they're calling me off the record and saying, okay, I'm not going to be able to get this,
Mhm.
but like I'll be able to get this.
Right.
And like that's happened all the time, off
All
the
the
record
time.
conversations where they're like, okay, how important is this? Because I just want you to know that that's going to be the hardest thing to do.
Right.
And I'll be like, okay, we'll push for XYZ because I
Right.
know that this is where it's going to move the needle for them. And I can see, knowing them, it's like maybe they want more money, maybe they want a bigger title because they're going to leave later,
Right.
all of which are important, but like you're going to get something,
Exactly. Exactly.
you're already going down this road. They've spent a lot of money to find the right person, or they've already invested a lot of money in keeping you there. They're going to make it happen.
Right. And I think the other thing that we didn't talk about yet that we should is, my sense is for people who may not be at the top executive level, they're like, well, do I really want to spend the money on an attorney at the
Yes.
outset? Right. Always spend the money. It's worth it.
Always spend the money.
Always
It's
spend the money.
always worth it. When
And
I tell all my clients, it's like, I will get you more money so you won't even see that you're paying me.
Exactly. And to be honest, a lot of times one of those negotiation points should be for legal fees. So
Exactly.
if you're an employee negotiating a deal, there's always some budget. Maybe it doesn't cover the full amount, but I think that's the best money you're going to spend is on the front end.
Exactly. So what about now? I'm excited to interview you is because you represent the other side too. So you represent individuals, but you also represent the companies.
Yeah, that's right.
And a lot of people get worried that the companies are going to be like, well, I'm not going to negotiate with an attorney. Because quite frankly, I had that happen to a client of mine. It was Condé Nast, and I'm going to put them on blast because it actually happened. They had an in-house employment, not in-house, but they hired an executive recruiter. The executive recruiter wanted to only negotiate with my client and refused to negotiate with me.
Yeah.
And she was smart because she'd been my client for a long time and had said like, no, I don't negotiate my own comp. And he wouldn't. And they rescinded the offer.
I'm shocked.
Yes. No, it's awful. Condé Nast, awful. This happened within this year. Awful. Wow. You should not be doing that to people. There's no way the top executives, and she was going to be a C-suite person in Condé Nast, and it's not okay to do that.
Wow. That's interesting. Yeah. No, I mean, I think, look, you're right, is to have an attorney to have discussions that are a lot of times tough discussions to have. So that's.
Have you experienced that in other companies of yours?
Yeah, I think, look, sometimes I think some of it is posturing, right?
Yeah.
Look, like I said, I do a lot of company side representations. It could be posturing, I think, but at the end of the day, I've never had that happen.
Right. Okay, great. So obviously you don't represent Condé Nast. So
noted.
But that is, I wanted to put that out there. Because that was the exception. I have never in my 20+ year career have seen that either. And it's grotesque, and the executive recruiters should be ashamed of themselves as well for that, because it's not okay. You should be able to represent yourself. If you're good at your job as an executive recruiter, then you should be able to go against an attorney and go up. But I've also had executive recruiters who try to force my clients to negotiate with them and keep saying, oh, it's the most you're going to get, most you're going to get. And it's just going to make them mad if you come in. And I came in and I got another $200,000 for my clients. you
Right.
know, because it's posturing on their part as well. So,
Yes.
and they're always going to say that, you
Right.
know, they're always going to say they
Right.
don't have money and this is the top of the band and whatever. Don't listen to that,
Yeah.
you know, hire somebody to do it for you and push.
Yeah. And JJ, like you said, there are also, I mean, we talked a lot about the money piece, but there's so much else in an
Yeah.
employment contract that is so important. And I
Yeah.
think if you don't have a lawyer, a lot of that can get lost. So to your point, reporting line duties and how those things play into and severance on the back end. So for example, one thing that I focus on a lot in terms of negotiating contracts is, what are the severance events? So
Yeah.
if you get terminated without cause, meaning, if you've, frankly, if you're let go by the company without having done something bad, committed a felony, had a Me Too incident, that's typically a severance event. Well, on the flip side, there is protection that we refer to as, good reason protection, which is basically, a number of things that fall into a category of if your job has been changed in such a way where essentially your service relationship is different. So that could mean someone changes your comp in a material way. It could mean that you used to report to the CEO or to the board, and now they've put someone in between, so you're not a direct report. It could mean that they've changed your title or the budget that you have authority over. Those things are can be reasons for you to resign and get severance. Very customary in C-suite level agreements, and different formulations of that protection are customary kind of the lower you go down the chain as well. But those are things that are negotiated on the forefront of putting together
Yeah.
a contract, and you need to be having those discussions with your attorney to understand kind of what is important to me about is title important to me, is reporting line important, is my budget or my discretionary authority important. And you need to be having those discussions so that those protections can be appropriately woven into the contract as well.
Yeah, because oftentimes things like good reason termination, that your ability to terminate yourself because of these things have changed, is not necessarily in the first draft of your contract.
That's right.
should
And it's often
also,
not in a term sheet either, to be
yeah,
honest.
or on a term
Yeah.
sheet. So they need to be added because they're quote unquote a material term,
Yes,
And
absolutely.
so you negotiate all the material terms, your compensation, how long you're employed, who you're reporting to, where you're working, your responsibilities, your severance. All these are material terms that you need to negotiate up front. And then when they
Mhm.
get put in the agreement, that's not when you hire an attorney. You
Right.
need to hire the attorney to negotiate for you
That's right.
while with all of these material terms. So
Yeah.
that's a very important point.
Yeah. And then
So
the other one I wanted to mention, because I'm seeing this more and more, and I am by no means like an IP attorney, so intellectual property. But
yeah,
I think one thing, and it's one thing that we're seeing a lot of is, the line between what is mine as a personal matter versus what is mine as a professional matter in terms of social media presence is becoming very gray. And there have been a number of cases where you've had pretty high level people leave a job and then have their Instagram account or their Twitter account come into question. Who owns that? And so again, when you're negotiating a contract, there are typically very broad provisions as to who owns the IP that's created, both when you may be employed. You could be doing it on your off time. If the contract drafting is broad enough, it could capture a lot of that stuff. So especially for people who are in more of a creative field where
right.
social media presence is important, it's something that I would really caution people to focus on, and to have an attorney who's whether it's having an employment attorney pull in a colleague who is an IP person and take a look at those provisions, because it's super, super important. And again, just because of the way social media has become so important in so many fields now, it's a caution to people out there that make sure you have someone reading those provisions on your behalf when you're negotiating a contract.
Right. No, that's very true, especially, with creatives in particular.
Yeah,
It's a big thing. Let's talk about another really massive component that is really difficult for people to understand, and that is the equity piece.
sure. Sure. I'm happy to. This is my favorite because I do a ton of work in this field, obviously, and I think equity is probably one of the most confused elements of
Yes.
compensation, even for people who practice in this area, because people use different terms to describe different things, and it can get
Yes.
very confusing.
Right. Great. So can you just break down, starting with the most 101, what does equity mean in a compensation agreement?
Sure. So I guess from really taking a step back, just generally, a company is owned by its stockholders, right? That's the ownership or the capitalization of the company. Equity awards are essentially, a derivative of ownership. So the thought there is, while you have management leading a company, you want their interests to be aligned with the other owners of the company. And, the way you deliver that ownership is through an equity award. So for purposes of an employment agreement, there can be numerous buckets of types of equity, meaning, is it a stock option, a restricted stock unit, or the contract could just speak to, you're getting a big award at the time you join and commence employment with the company. And it also may address, your right to awards every year. Is there an annual component of the equity award? So there's lots of different buckets, and there can be lots of different types of equity that you may be entitled to.
So break down what the difference is. Like, what's an option versus a restricted stock unit?
Sure. So an option is essentially a contractual right for you to buy a share of stock at a designated stock price at some time in the future. So just generally speaking, if you're joining a company and at the time you're joining the company, the fair market value of the stock is $10. As an employer, I would say, we're so great to have you. Here are 100 options. They're at a strike price of $10, meaning, you have a right to buy 100 shares of stock at $10. The key is it's sometime in the future. You don't get that right always, up front. You typically have to stay for, you vest or you have a right to actually exercise that option. Let's call it, 25% after the first year, 25% after the second year, and so on and so forth. The goal being that, you stick around, you're helping the company drive value. So at the end of the vesting period, the stock price is worth, $25, so that you can then recognize the value between the $10 exercise price and the fair market value of 25 when you exercise.
Right. And so that means that vests over a certain period of time. So when people hear that term, it's vesting. So that, and it goes over a period of time that if you don't stay, it doesn't fully vest. Right.
That's
And
right.
these are all terms that sometimes you can actually negotiate.
Absolutely.
Right. And
Absolutely.
so you can negotiate. I always try to get some upfront the day they start, and, vesting period, a shorter period of time.
Right. And I
Then-
think another really big add value on, the equity component, especially like if you're at a startup, vesting over 4 years might mean nothing, right?
Yeah.
Because there might not be any type of real, in that context, you're typically not exercising because you would have to come out of pocket and pay the exercise price to receive the stock. So really where the value in equity is at an earlier stage company is the ultimate exit event when that company is either purchased or there's an IPO. And I think what's important to think about in that regard is, if I'm not there on that day, what has happened to my equity? Because,
Mhm.
You may vest over 4 years, you may hold vested awards, that's great. But then the contract might say, if you leave, you have 90 days to exercise. Well,
Mhm.
90 days is not a very long time when you're thinking about a horizon of much longer for a liquidity event. So it's just, these are things that we should be thinking about, kind of going into the deal. To your point, what's the vesting? Can we negotiate having a slug up front? What are we looking like on a termination? Can we hold the award? Can we exercise? If we exercise, can the company buy me out? There's all these questions that come into play, and those are oftentimes, the important pieces that, to your point, can be negotiated when you're coming in the door.
Right. And so it can be great. It can be a massive value. I think there are a lot of people who worked early on at Uber and Facebook and all of these companies that, Amazon and Google, that did really well. But, you can come on later and not do so well. If
Yeah,
you're at WeWork, you're not so happy,
right.
But then the other thing you have to understand is, if there's not some kind of liquidity event and you're getting it as, like, talk about what happens when you have to exercise and the taxable, to come out of pocket. Can you go into the details on that a little more?
Sure. So I think, yeah, that's a huge thing that people don't realize. So if you have options and you choose to exercise, outside of a liquidity event, again, putting aside some nuances that the award could have, what that means is you actually have to, pay cash to exercise the option. And typically the difference between the stock you get and the price you're paying is ordinary income. So you have to pay tax on that. And, again, there are some nuances with certain awards, but, you then would have a capital gains expense again down the road if there was a liquidity event. So you need to be mindful of, kind of tax up front in terms of what we call ordinary income, or the compensation tax could be, and then the consequences down the road, if there is a liquidity event and you continue to hold that stock.
Right. So overall, look, it's great to have equity, but don't sacrifice your salary for it,
That's
because you
right.
don't know. It's so
It's
speculative.
Yeah.
You don't know what's going to happen down the road. And maybe if you can afford it and you're like seeing how the management is run and you're part of, the executive team and seeing that there's potential buyers, etc., you might feel differently than if you're someone who's in the weeds and just, have nothing to do with where that company is going and have no real visibility in that. You might think differently about it.
That's right.
So let's just give like a tactical example. If somebody has an exercise price of $10,
Mhm.
they get 100 shares,
Mhm.
right? And then they decide to leave and they vested 100% of it, like what that means.
Yeah. So I have to now remember the math here. So they have 100 options at a strike price of $10. So if they were fully vested in those awards and wanted to exercise, they would have to come out of pocket and pay 10 times 100, or $1,000
Mhm.
to hand over to the company to buy those shares. They would then, receive equity. It could be, let's call it, it's at $20 at the time. And they would then recognize a tax impact of the difference between I guess it would be $2,000 minus $1,000 they paid. So there'd be a tax recognition event upon the exercise where they'd have to pay tax on that $1,000. And I think what's difficult is that, in certain contexts, for example, in public companies, it's quite common to net the tax out of the shares because there's liquidity on a public market and there's a market for those shares. That's less common in a private company context. So you may be in a situation where you have to actually come out of pocket and pay tax in
Yeah.
addition to the $1,000 you've paid to buy the shares.
Right. So you have to think about it. It's like, I've just paid for these pieces of paper, right?
Right.
And then now I have to pay taxes on the pieces of paper in a private company. I still can't do anything with them.
That's right.
So I'm coming out of pocket for taxes on something that is quote unquote worth, $2,000 less the $1,000 I paid. So I've made $1,000, but in paper, but it's not like I can go to the bank without $1,000, that
Right.
$1,000.
You can't really do anything with it.
And going forward, I could go back down.
That's
right.
right.
It could go bankrupt. So I'm taking those chances. So you just need to be aware. It's like, I just want people to understand that there could be negative things that happen. Right. And so, with employees, a lot of times, there is this, liquidity event, meaning, they sell the company and then everybody gets paid out, or
Right.
they go public and then, there's usually
There's a
some
market.
kind of restriction where you have to wait 180 days and then you can cash out all your stock, right? But in a private company, it's a lot harder because you're just holding on to this thing, hoping one day you can cash it in and make your money back on the taxes that you already paid for it.
Yeah, that's
Right.
right. That's right. But I think, to kind of bring this full circle back to our talking about the employment agreement, for example, if I was negotiating for an executive in this context, I would try to negotiate one for, net tax withholding and net exercise, meaning, you know, basically put that executive in a position where, they don't have to come out of pocket with cash for that exercise, and they don't have to come out of pocket. It's really putting it on the company to net out the shares that they would have to pay for the exercise price and net out the shares that they'd have to pay for the tax. So again, still speculative, and I agree with everything you said, but if you're thinking about this in terms of representing someone and negotiating a deal, there are little tweaks we can make around the edges to hopefully make that economic situation better for the executive.
Or just can you make sure you're like super clear on the net exercise, what that means exactly?
Sure. So in the example, we talked about someone having to come out of pocket for the $10 to exercise one option. And what net exercise allows you to do is say, well, instead of me paying $10 to buy a share that is now worth $20, I will let the company essentially look at the value of the shares that I would have purchased and, deduct from the shares that would be delivered to me, enough shares to cover the exercise price. So if I were exercising an option and, getting, let's call it 2 shares, and, each share was worth $10 and my exercise price was $10, well, instead of me paying and getting 2 shares back, I would not pay and just get 1 share, because the company would essentially net out the amount I would have paid from the value of the stock. And that's, meaningful because you're still in the same economic position, but you're not having to come out of pocket to, buy the shares.
And do you see companies agreeing to that?
Yeah. Yeah. I think, look, again, it's less common in the private context, but you don't get it if you don't ask for it. So
Right. And what about the taxes then? How do you deal with the taxes in those situations?
it's the same. Look, I think it's the same thing. You see this both in the stock option context, but also, in the companies I represent. We talked a little bit about restricted stock units, and that those are very customary awards where very simply it is essentially just, again, a right to have a share delivered to you in the future. So again, I have to work 4 years and I'm going to get 25 shares in year 1, 25 shares in year 2. So there's not that exercise construct built in. It's a full value award. And again, for a person in a private company context, when you receive those awards, it's a taxable event to you. And, if you don't want to have to come out of pocket and pay the taxes, you could try to negotiate with the company to have them essentially, net settle that award. So as opposed to getting 25 shares of stock, I might only get 15. And essentially the 10 are taken by the company and cash is paid over to the government on my behalf.
Right.
So,
that's the important part, is it's not like they're just giving you less. There's still an accounting provision to the tax, to the IRS and for taxes for you that happens on the back end from the companies. Right. Yeah. And they do take it on. It's not like it's unusual. These are things that actually happen.
And they don't want to look at from representing a company, they don't want to agree to do this for everyone a lot of times, right? Because it goes to their cash flow. But if you're, an important hire and you have someone representing you that points this out in the front end and says, we should be asking for this because, you don't want to be strapped, 5 years from now having to come out of pocket for this, oftentimes you can get a company to agree to this.
Right. Amazing. See, there's all these things you can do if you just hire an attorney.
That's right.
And then, so what, other than all of these, are there any other mistakes you see the executives making when you're like on the other side going, God, they really should have asked for this?
That's a great question. I think, there's really pieces around the edges that I think people forget about. So just going back to compensation and thinking about the annual bonus. So, an annual bonus is a pretty customary concept. And a lot of times, for higher people coming into the C-suite of a company, you'll have what's called a target. So the target might be 100% of your base salary. I think one thing that is oftentimes missed is, at the front end, really crystallizing what the performance metrics are going to be. Are they, 50% financial based and 50% more discretionary? What is that mix? Who's deciding it? When are they telling me what the metrics are? So, a lot of times having those conversations up front and really putting that in the contract can put some protections around the individual so that they know, this isn't just some totally like discretionary award as to, how the CEO is feeling on the day that he or she makes that decision. It's, 50% EBITDA, 25% sales, and then 25%, individual contribution. So I think that's, a big piece. And then I think the other piece, we mentioned the IP, which I really think is important.
Yeah.
And then again, I think there are also a lot of, it's almost like the miscellaneous provisions at the end of the agreement that no one wants to look at or focus on. But these could be things like, restrictive covenants. What is the non-compete? What is the non-solicit? Is it a non-solicit of customers or employees? And how do you think about both the term of those restrictions, but also, how broad they are in terms of geography and covering other types of businesses, and, whether there should be carve outs for certain things. Those are, really important provisions that, you should be, having discussions with your attorney about it at the front end, negotiating a deal.
Yeah, certain things like one non-solicit is not allowed in California and another one is. Which one is it again?
So the customer and like client is not allowed, and then employee non-solicit is. But there's, in California is, a state where you should really have a California barred attorney in, because there's so many nuances to the law there, and there are, non-competes are kind of on their face not allowed, but again, there are exceptions to every rule, and there's even an exception to that rule. So again, it's really important here in California to have someone that knows, the law of the land in that state.
Yeah, and not only that, like think about it in the context of severance. Like I've seen people who have, they'll come to me, they've been in a company for a long time, and then they'll come to me and like, here's my agreement. And I was like, oh my God, do you know you have a non-compete that exists even if they fire you for no reason? Like,
right.
And then you can't go work. And you have no, like, what? Like that's, and they don't have to pay you severance the entire time there's non-compete. Like, that's just crazy.
Right. There should from my perspective, there should always be symmetry.
Yeah.
Between, what is the length of severance, and what is the restrictive covenant period. Yeah. And a lot of times people forget, like, look, your severance could be tied to your base salary, but what about your cash bonus component? Shouldn't that be a factor in what type of severance you're getting as well?
Exactly.
So again, having someone representing you and having those conversations, which, can get awkward and difficult, will, pay off in the long run.
It could be awkward and difficult, maybe if you're the employee sitting on the sidelines, but it's not something that they have never heard before, right? Like they've heard it before, and they're prepared to talk about these things.
Right. So are we, right? This is our job. We have these discussions.
Exactly. We have them all day. I have what people think are super uncomfortable conversations and super stressful. I have like a Tuesday for breakfast. Like it's totally fine for me. I'm used to it. Like,
Right.
And then we can talk about our kids after. It's like, this is what we do. And like, we're used to it. So amazing. Well, thank you. This has been awesome. And I love talking about these things because I think it's really empowering for people to know what their rights are. Absolutely. And what is going on in particular women, and that this is a total normal state of affairs. And companies expect these things and expect to have these conversations. So in somebody in a like prestigious, big Wall Street firm who, basically takes these hard-nosed positions, they still are like, yeah, of course we have these conversations all the time and are representing, our companies against executives or executives against companies. So thank you so much, Regina, for all of this. I always ask one question at the very end, which all of my guests know, and that is, what is the worst advice you've ever received?
Wow. So I think the worst advice I ever received was probably not to trust my gut, not to trust my instinct. I just to tell an anecdote about this, JJ, I mentioned to you, I left my previous firm. I was relatively junior and I went in-house. And looking back, I knew literally the day I set foot in that office, my first day of work, that I had made a mistake in going in-house, because it just had felt off to me the entire time. And I knew I shouldn't have done it, but I let a lot of other things get in my head and, thought for various reasons it was the right move. But if I had trusted my gut, I would have never taken that job.
Right. Yeah. Women's intuition, you have to
Right.
trust it
That's
in
right.
all areas, personal, professional, and all everything. Well,
right.
thank you so much. This has been awesome. If people want to find you, how can they do that?
So I think the best place to find me is on my firm, the Weil Gotshal website. You can search my name, Regina Readling, and I'm there on the executive compensation page.
Amazing. Thank you. And to everyone listening to this episode, I'm sure you learned a lot. Me, even as a practicing attorney doing these deals, I always learn a lot. So thank you so much for listening to this episode of Taking Care of Lady Business. I'm Jennifer Justice.